The honourable member for St. John's East.
Thank you, Mr. Speaker. And I would like to indicate at the outset that I'm sharing my time with the honourable member for Victoria. Bill C-51 is now before us, Mr. Speaker, to debate something of great importance to the people of Canada. It's called the Anti-Terrorism. I think the short title is actually called the Anti-Terrorism Act 2015. And there's a real question as to whether it's what it's really about. In fact, the Globe and Mail, one of the oldest and most prominent newspapers in Canada, say, on close inspection, Bill C-51 is not an anti-terrorism bill. Fighting terrorism is its pretext. Its language reveals a broader goal of allowing government departments, as well as CSIS, to act whenever they believe limply defined security threats may, not will, occur. Now, that's a pretty fierce condemnation of a piece of legislation by what purports to be a serious government interested in dealing with terrorism. Now, let's make no mistake, Mr. Speaker, terrorism is a real threat, and everyone agrees that public safety is a top priority for any government. But Canadians do not have to choose between their security and their rights. This is, in fact, a false choice presented to the people of Canada by this government and by the Prime Minister. You know, the former Minister of Foreign Affairs, the member for Ottawa West, je pense, said the other day when he was announcing his retirement as Foreign Minister, he gave a quote from John Diefenbaker, which said that the House of Commons at Parliament was the custodians of the freedoms of citizens. And I believe that's right. And what we are doing here today on this side of the House is doing what we can and must do as parliamentarians to protect the freedoms of Canadians. Because that's the issue here. The issue here is that we need to have concrete measures that keep Canadians safe without eroding our freedoms and our way of life. But unfortunately, time and time again, this Prime Minister and this government is putting politics ahead of principle. Once again, Mr. Speaker, the Globe and Mail on the 1st of February, say, under the cloud of fear produced by repeated hyperbole about the scope and nature of the threat, he, referring to the Prime Minister, wants to turn our domestic spy agency into something that looks disturbingly like a secret police force. Canadians should not be willing to accept such an obvious threat to their basic liberties. Now, where does that come from, Mr. Speaker? It comes from the provisions of the bill itself, giving additional powers to CSIS, for example, that it doesn't already have and arguably does not need. And secondly, information sharing broadly between 16 government departments, which, again, is not specified as to be limited in nature and, again, causing problems that have been described and outlined by many, many citizens of this, prominent citizens, former prime ministers, former leaders of political parties, academics, legal experts, former justices of the Supreme Court of Canada, all of whom have condemned this legislation as going too far and giving unnecessary and dangerous powers to government agencies, with a profound lack of parliamentary oversight. Now, you know, the government's position on oversight is that we already have enough. We have a robust system. Well, we don't. We don't have any system of oversight for the Canadian Border Services Agency. We have an appointed body dealing with CSIS, CERC, which is not an oversight agency. They say so themselves in their most recent report, and they make the distinction between oversight and review. They say we are a review agency. We look at things after the fact, sometime later. We look at it after the fact. We don't place oversight on a continuous basis on what's going on in the moment, in the day. So they're not an oversight agency. They say so themselves, and they recognize that oversight is a different value and something that's required. There are provisions that have been put before this House to provide the kind of oversight that we could use. Oversight that some of our Five Eyes friends, the so-called Five Eyes of intelligence, have. Australia, United Kingdom, the United States of America, robust parliamentary or congressional oversight with the power to want to know what's going on and to keep an eye on things. This has been rejected outright by this government. There was a bill before this House, C-622, a private member's bill, taking and modernizing a piece of legislation that was before this House in 2006, a piece of legislation arising out of a committee that you yourself, sir, sat on, along with the current Minister of Justice, who said at that time that this was a desirable and necessary and important measure that should be undertaken. That bill died on the order paper. But the bill C-22, which takes that and modernizes it to some extent, and I'm not saying that we agree with everything in it and the model that's there, but it was there before this House, and it was defeated by this government at second reading. Also before this House is motion M-461, a motion that I presented to the House on October 24th, 2013, calling for a select committee of this House, a special committee, like the one that you sat on and that the Minister of Justice sat on, to devise the best and appropriate form of oversight by Parliament that might be required given the changes in circumstances since your committee of 2004 and given the experiences of other jurisdictions, and devise the best system for our Parliament. That has not come up for debate, although it was offered for debate, the Minister of the Government House Leader refusing to allow it to be debated, saying that there was no necessity for there to be any more oversight than there was. That flies in the face of all of the experts, Mr. Speaker. The academic experts, people who've studied this time and time again in academia, lawyers, judges, former leaders, former prime ministers, all of whom have said parliamentary oversight must be present in a system that protects the rights and freedoms of individuals in this country when we're dealing with this kind of legislation. It's extremely intrusive, Mr. Speaker. It gives CSIS, which is an agency which is basically a job is a spy agency, internal spy agency, to gather information and present it to the police authorities. Well, now they're being given police powers, including the power to disrupt activities. Now, I heard the Minister of Defence, who all of a sudden is a spokesperson for public safety. I don't know what happened to the Minister of Public Safety. He seems to have disappeared off the map since the new Minister of Defence was appointed. I see I only have 1 minute, but I'll make this point because it's an important one. He said several times over the weekend on various interviews that, oh, no, we're giving powers to the judiciary, not to CSIS. Wrong. The power to disrupt is there. Is there in the Act, in Section 42, given to CSIS directly. It's only when CSIS decides that whatever they want to do would actually violate the Charter of Rights that it can go to a judge. And the judge supposedly is allowed to tell CSIS that they can break the Charter of Rights and Freedoms. Now, Mr. Speaker, you know, you're a lawyer. You understand the Constitution. I don't think that that's constitutional. I don't think a judge can have a license by legislation to violate the Constitution of Canada. And that's what's here. And that's how bad this legislation is. And I know I only have half of my minute left, and I will leave it at that, that is itself enough to say that this bill is bad and wrong and unconstitutional and cannot be supported.
Questions and comments? Question commentaire. The honourable member for Winnipeg North.
Yes, Mr. Speaker. The member just finished saying that legislation is bad, unconstitutional, and cannot be supported. The New Democrats last week were saying that they're going to vote against this bill. Second reading, third reading. In principle, it's a bad bill. Yet, Mr. Speaker, over the weekend, we hear the leader of the New Democratic Party saying that if, in fact, they were elected to government, God forbid, they will not revoke the legislation, that they will leave the legislation in place. There seems to be some inconsistency with the NDP positioning on the issue. In principle, if you support the legislation, if it ultimately passes, and that's what the leader of the New Democratic Party is saying, if in fact he formed government, then why would you be voting against it in principle here? In the Liberal Party, we have indicated that in principle we support the bill, but it has to be amended, and we are pushing hard for those amendments. Why won't the New Democrats join the Liberal Party and be more transparent on their position and just say what needs to be said, and that is that in principle, yes, the legislation does have some steps worthy of supporting through the process, but it must be amended, and push for those amendments.
The honourable member for St. John's East.
Thank you, Mr. Speaker. I don't know where he gets his information. I'm sure he must have misunderstood whatever might have been said by the leader of the opposition, because we're clearly not going to support or keep in place, if it's passed, unconstitutional legislation. And I can't imagine how the son of the father of the Charter of Rights can ask his caucus to vote in favour of a legislation that's clearly gives a judge the power to override on an individual case in secret the Charter of Rights and Freedom. So if you're pushing hard against it, you're pushing with a straw, I think, Mr. Speaker, when I say to the honourable member.
Questions and comments? Question commentaire. The honourable member for Edmonton Strathcona.
Thank you very much, Mr. Speaker, and I'd like to thank my colleague for his address on this bill. I'm sure that he could speak for several hours on the concerns that he has with the bill, but put it very succinctly in the brief time he had. I think, Mr. Speaker, that what the honourable member from Newfoundland and Labrador has raised is one of the most significant aspects of the bill, and the misleading, uninformative statements by the Minister of Defence on this bill. In fact, this very bill, as the member has pointed out, adds very strong additional powers to the intelligence body. As he said, the minister has said, oh, the new powers are only to the judges. But that is, could he elaborate on that? That my understanding is it's only in the discretion of CSIS, if they choose to think that maybe they're acting beyond the bounds of the law, then they could go to a judge.
The honourable member for St. John's East.
Thank you, Mr. Speaker, and I thank the honourable member for her question. It is quite astonishing, actually, that the discretion to decide that whether or not there's a violation of the Charter of Rights. In fact, the section under 42, Clause 42, actually says the service shall not take measures to reduce the threat of the security of Canada if those measures will contravene a right or freedom granted by the Charter of Rights and Freedoms unless they go to a judge. So the determination has been made by them that they actually will violate the Charter. Now, who is CSIS to make these determinations in the first place? And only if they're sure it will, then they go to a judge. I think it's, you know, when you look at the experience of CSIS in dealing with the judiciary already, they've already been found to have misinformed, shall we say, politely. In other words, not told the truth to Mr. Justice Mosley in an application in relation to getting secret powers. And so there's a real question here as to whether or not whether this will be abused or is likely to be abused or is possible to abuse it, particularly if there's no oversight.
Resuming debate.